So we have two wonderful speakers tonight. We've got Sarah Branson, who is a barrister from Coram Chambers. She's a specialist family barrister and mediator, and a founder member of Coram Mediations at Coram Chambers in London, and was called in 2001. She evidences her skill and dynamism through winning Junior Barrister of the Year in 2018, and marked as leading junior in 2023 in the Legal 500, who describes her as accomplished and energetic, and also ranked in Chambers and Partners. Sarah is instructed on interjurisdictional work, including in Iran and Afghanistan, through her work through the UNHCR. Sarah acts for local authorities, children and parents in complex public law proceedings, including the most serious of non-accidental injuries, and where one parent has killed the other. Sarah also has a thriving private practice representing parents and children in the most complex of private issues. Sarah is described as not being afraid of putting forward a difficult view if that is what is called for. Her oral advocacy is her strength, and she has case law at her fingertips, making Sarah quick thinking on her feet. Sarah's ability to explain in relatable terms to lay clients complex and complicated legal concepts makes her in demand by parents and local authorities in equal measure. This skill makes her approachable and relatable. Sarah has a particular interest in the science of hair strand testing and has written articles and presented papers on the subject. I personally welcome Sarah to Liverpool, where I practice, as Sarah gained her undergraduate degree right here. We also have Paul Hunter, who many of you will know from FTS, Forensic Testing Service Limited, where he is the technical director. He's based in West Yorkshire with 110 employees. Paul's previous work in substance abuse started in the 1990s, involving the introduction of a new patent technology and unique service to reform the provision of clinical and legal evidence for substance abuse street clinics, probation services, and crime reduction partnerships. This work highlighted the poor grasp lawyers and courts had of the complex science behind forensic testing, which was particularly noticeable in childcare proceedings between what the court required and what the industry provided. The existing services were not fit for purpose, and FTS was set up in 2009. Paul is an expert in the analysis and reporting of tests carried out on biological samples for substances, both pharmaceutical and illicit, and alcohol biomarkers. He's an experienced court expert, and I can attest to that because I have had cases where Paul has given evidence on numerous occasions, particularly with the complicated issue of runoffs. Paul also undertakes CPD and training for local authorities, solicitors, barristers, local family justice boards, judges, and magistrates. He has co-written a paper with Professor Alexander Forrest, presented at the TIAF conference in 2019, concluding that evidence-based opinions should be provided rather than test results using cutoffs. In 2019, FTS appeared in the Parliamentary Review as a best practice representative on drug and alcohol toxicology for family law proceedings. This set out the inadequacies of the binary system of positive and negative drug testing. I welcome you both. And Sarah, I think you're going to start with the first slide.
Yes, thank you. I'll screen share now. Okay, I hope that can be seen by everyone. So
yes,
we're going to
be on my screen, Sarah, so thank you.
Perfect. We're going to do a very brief overview about what's wrong with current practices of hair strand testing and how best to challenge disputed results to get the best for your client. It's an enormous topic. We are only going to be able to give you a taster, but we hope to cover some of the main points for you today. I want to begin. Oh, there we are. I want to begin by saying that this is an extremely important and current topic. And you will see on screen two articles that appeared in the Guardian on Saturday and a fuller piece on the TBIJ website on this very topic. And watch this space for potentially a BBC piece on it. So it's something that's hitting the main stream media, as well as being something that we all know about and are fighting for change in respect of. I want to begin, before I turn to Paul to talk about some of the science, to do a really brief overview of the law. You will need to read these authorities in detail, and they're not long, but just to pull out some of the salient points on the authorities when we think about how best to challenge this evidence, because in fact many of the toolkits for challenging this evidence are helpfully contained within the authorities. The first authority is REH. It's a well-known authority to us all, I'm sure, from 2017 High Court, Peter Jackson. He made it clear in this authority that hair strand testing evidence is opinion. Some evidence is factual, but this forms squarely in the category of expert evidence, the experts expressing an opinion. In order for these results to be of use, they need the person providing that expert opinion needs to describe the process, record the results, and explain their possible significance in a way that can be clearly understood by those who are relying on this information, and to fully and faithfully report all findings. So that's High Court authority, but makes it very clear that this is opinion evidence. The very recent Court of Appeal authority in RED really enshrines that decision at Court of Appeal level, sets out that it's an evolving field, and that it really cautioned that hair strand testing has its limitations. We're going to come on and look at some of those limitations shortly. And this is quite an important thing to draw out of RED, that the variability of findings in hair strand testing doesn't call into question the underlying science, but emphasizes the need to treat the data with proper caution. What that means is the process of extracting drugs from hair, something that Paul will no doubt explain with more technical detail than me, is sound. But what is important is that the interpretation of what any drugs found in the hair means is understood and treated with proper caution. Other headlines from authorities are that because these results are presenting it as a number, and of course the numbers are not the same thing as the interpretation of what those numbers mean, that is the opinion bit, the numbers being the extraction of the drugs, whatever. There is a risk that these results will acquire pseudo-certainty because they present as in the form of numbers, and that comes from REH. Also in REH, the only thing the experts could agree on in REH was that they couldn't agree because there are so many variables when interpreting the numbers in the hair, in relation to color, race, hair condition, and all of those factors we see listed, as well as the inherent variables in the testing process that can mean to different conclusions being drawn from the same numbers if proper caution is not used. And it's absolutely clear in all the authorities, including the last one that I list there from 2017, that this form of testing should never be regarded as determinative or conclusive, but needs to be looked within the wider evidential canvas. It's not, it is wrong to say these are the numbers, this is a positive test, and therefore this person has abused or used drugs for reasons that we're going to come on and outline. So looking then at those main principles very simple principles extracted from the authorities, we know that there are variables in relation to hair color, race, hair condition, body size, a whole list of factors, and there are variations inherent in the testing process. And the question that we pose is, to what extent are those factors currently factored in within current practices, particularly when the use of cutoff levels is employed in interpreting those results. And when using those cutoff levels, you are simply saying above that line, it's positive for chronic use. Below that line, it's negative for chronic use. And really, unless a hair company testing, an expert who's interpreting these results, is taking a full forensic history and factoring in all of these matters which we know are relevant to the interpretation of results, then how reliable are these reports that we get saying, we've got no information about this person that's provided hair, we have tested their hair and we've applied a cutoff level, and this is what the computer says, basically. So Paul is now going to talk to us about some of the difficulties when cutoffs are applied in interpreting these results.
Thank you, Sarah. Yes, I'll just come on to that slide in a second, but I think as Sarah's made the point for me, but a test result in isolation is completely meaningless in terms of whether somebody's used a drug, not used a drug, consumed alcohol excessively or not. And it's probably quite a shock, but you can have hair samples tested and we don't find any drug. And that's going down way below cutoffs that are used by the industry. You can have no drug in a hair in those who are consuming drugs on a daily basis. And conversely, you can also have levels that are so high in the hair that we have to recalibrate them to get them into a concentration range in people who don't use drugs. So it's futile to think you can come up with a number above which you can be certain that somebody's used a drug and below which somebody hasn't. And I think also that the point that Sarah raised earlier, which I think just to reinforce, for an organisation, a testing company, to report a negative result when they know there is drug in that sample. We know this because of the testing that we do. We don't apply cutoffs in our laboratory, but numerous reports that you receive with negative results, there will be drug there. It's just that because it fell below the cutoff, those who were interpreting the results felt it wasn't relevant. And how wrong could they be? You will see in a moment. Moving on, I'm just going to cover off some of the, I guess, quite striking components of in terms of influences that have a really significant impact on what you find in the hair. This was a study conducted by Rollins, a researcher who's done a lot of work in trying to establish whether or not factors such as hair color could have an impact on the concentration level of the drug in the hair when they're using the drug. This is a study that looked at a whole range of individuals with different hair colors, all the way from auburn, ginger, through grey, blonde, light brown, dark brown, black. And he also segregated those black hair into 3 ethnicities. So he looked at Afro-Caribbean, Asian and Caucasians with black hair. And he did 2 things. One, he dosed them with a drug, an opiate. In this case, he used codeine. We can't really load people up with heroin. So over several days, they took the same dose, a high dose of codeine, the top end of a therapeutic dose. He then measured the amount of codeine in the hair of each of these individuals and measured the amount of dark melanin in their hair. As these numbers show you, those with red hair, the results that came back were somewhere around about 60 or 70 picograms. Blonde hair, grey hair, a little higher. Light brown hair, 250, 300. And as you move up the scale, it gets higher and higher until you get into the black hair, when the average of the three ethnicities was around about 1,000, 1,100 picograms. Now, in that, within the ethnicities, it could range everywhere from about 800 in Caucasians up to about 2,000 in the Asian population. Caucasians down about 800. So as you can see, this was presented to the industry back in 2004, and yet hair color is not considered in the interpretation. Sorry, Sarah, did you move it on again?
Yeah, and of course, if you were to apply a standardized cutoff that didn't take account of hair, you would have positive if you have black hair, and negative if you have blonde hair, and you've used the same drug over the same amount of a period of time in the same quantities.
Yeah,
so
the industry apply a 200 picogram cutoff. So as you can see, anybody with moderately brown hair taking large doses of codeine would be positive. Anybody below that would have been deemed to be negative. So this is both a hair color bias, but also an ethnic bias as well, purely based on hair color. One thing I'll just quickly mention, you've seen high, medium and low descriptors probably on reports. In that study, you have everything from negative all the way through to high for the exact same amount of drug. This is, Sarah mentioned the variation between different laboratories. It's a very complex testing procedure, extracting a drug from hair, decontaminating the hair first, analysing it, reading the results, etc. No two laboratories will get the same results because we do not use the same identical methods or indeed equipment. And therefore, if you send the same piece of hair, in this case, this is an external quality assessment scheme, and laboratories who are accredited receive homogenized powdered hair with a known amount of drug in it, and we all have to test it, send back results, and check that we're all within an acceptable variation. In this study, the laboratory number 17 on the right-hand side, every one of these grey bars is a result from a laboratory for cocaine. Laboratory number 17 on the right and the 2 on the far left failed. All the rest of the laboratories got within an acceptable range. Now, if you consider the red dotted line across the middle as a cutoff, if you were to send your sample today to say laboratory 14 on the right-hand side, they'd have tested that sample, found it to have a certain level that was in excess of the cutoff. They would report that positive and tell you that your client is a chronic user of cocaine. Had you chosen laboratory 37, also accredited laboratory, testing the identical piece of hair, they would have found the level below the cutoff and would have reported that negative, telling you that there's no evidence your client has used cocaine. Now, there's nothing wrong in terms of the validity of the result and the reliability of the result. We just have to accept that there will always be a variation. The same laboratory testing the same sample will get slightly different levels. The big problem here is applying one threshold, above or below, because if it's 390, if it's 499 picograms, you're negative. If you're 501 picograms, you're positive, and we cannot get it down to that level of variance within a laboratory. There's another very significant factor. Where you collect the hair on the head can have a profound impact on what you find in it. It's different for each drug, it's different for alcohol markers, but there is a variance. This is a study that was carried out on cocaine, looking at the distribution of the sweat profusion on the hair, which is the blue heads on the bottom, each little square representing an isolated piece of hair that was cut away and tested individually. On the top, the red squares are where there were high levels of cocaine, the white where there's very low levels of cocaine. Now, the difference between taking the hair from one area of the scalp and another area of the scalp, there was a maximum variance of 105-fold difference. So that could be, that could be typically with a cocaine user maybe somewhere between 10 and 20. So on one sample you take, it's 50 picograms. The next sample you look at, it's 500. The next sample could be 800. So you can get positive and negatives depending on where you get it from on the scalp. And the drugs like cocaine concentrate where the sweat concentrates, as you can see from the heads on the bottom, where you get high levels of sweat concentration, you get high levels of cocaine. Now, this will come on to what I'm saying is crucial when we're doing this testing. We have to collect chain of evidence. Not knowing, not having a photograph for the expert to see where you collected this from on the scalp means that you can't reliably interpret that sample. So, moving on.
Also, like when you're talking about chain of evidence, it's important, particularly when you're interested in timescales, to look at how much scalp hair might be left on the scalp. Because if your client is saying, I stopped using cocaine at Christmas, and that they say, no, there's evidence of use that postdates that, and there is a half a centimeter chunk of hair left on the scalp, and they haven't taken a photograph of that, then that's something that you can challenge.
Yes, and as you say, so it's without that. I mean, studies have shown that 1.5 to 2 centimeters can be left on the scalp, and if you're testing somebody for 3 months, then you're misleading them, because you're actually looking at back maybe 4 or 5 months, and completely misreporting the outcome. Looking at hair and what can directly impact on it externally as well. The hair strand, as you can see on the right hand side, that picture is a microscope picture of an intact piece of hair as it should look when it's not damaged. However, a lot of the hair samples we test do not look like that and have been damaged. Things like bleach, permanent hair dyes have a significant impact on the structure of the hair, and a single application of certain products can remove up to 80% of the drug, certainly drugs like cocaine, for example, and multiple exposures can remove more. Another problem when hair gets damaged is that drugs can be transferred along the hair. So, for example, if somebody has had a previous history of drug use, they maybe stopped 10 months earlier, have had no drug use at all in the 10 months prior to us collecting the sample. If they have long hair and they've bleached or dyed the hair recently, it will have removed huge amounts of this older drug in the older hair and transferred it to the hair that's been growing more recently, where no drug use has occurred. And we see some very significant transfer as a consequence. Thermal straightening plates can also add to that problem. Another problem is that those who are living in drug contaminated environments, if they have badly damaged hair as a consequence of these types of treatments, then the hair can act like a sponge, and it will absorb and incorporate the drug from external contamination more so, overstating the levels quite significantly in their hair. Moving on to the next hair slide. This is a picture of what happens when the hair starts to get damaged. You can see all those lovely clean coverings that were on the hair previously. These have now been swollen out and are starting to degrade and fall away, exposing the internal structures of the hair where the drugs are bound. And things like thermal straightening and dragging plates, hot plates over the hair, will cause this damage very, very quickly. And one of the factors also associated with heating hair, which happens with either curling tongs or the thermal straighteners, temperatures around 150 up to 200 degrees can be reached with these types of straightening products. When cocaine powder is heated, it converts the cocaine to a compound called AEME, anhydroeconine methyl ester, and this is frequently cited by the industry to confirm that the person that they've just tested is using crack cocaine. Crack cocaine is smoked, therefore heated, and those who do smoke crack cocaine do have this compound in their hair. However, if somebody's living with a drug user, for example, and there's cocaine contamination in that environment, there's contact with a user, so there's more contamination. They can pick up cocaine on the hair. They use thermal straighteners that will convert the cocaine into the AEME, and when tested, there will be a false accusation that they are using crack cocaine. So there are numerous factors that we touched on at the beginning in terms of variables and things that impact on the hair and what it represents. Here's another very significant factor, and as you can see, if we start to overlay these types of variances, with the lab, the hair color, the distribution in the hair, is it damaged or not, you can start to see why it's quite futile to think a number is going to tell you what it means. This is an example. It's a case I worked on about 3.5 years ago, and we tested this the female on 3 occasions. This was the last set of tests that we did on her for the final hearing. Initially, the first lot of tests we did showed that she had been using significant amounts of cocaine persistently over a few months. We subsequently tested her and found that she had made a big impact on that cocaine use, reduced significantly, and then there appeared to be a short period of abstinence. And this was the final set of tests we did about 5 months later. And she openly admitted that she had gone off the rails. There'd been a change in her life circumstances. She'd returned to using large amounts of cocaine as she had previously, consuming an estimate from her of around about £100 per day value of cocaine. That's what she was spending. Now, during the period from October to January, that very frequent use of cocaine persisted. In early February, she made a significant reduction to her cocaine use. She claimed 30 to 40 pounds in 3 to 4 days, and subsequently then in March, a further very significant reduction. Now, in this particular case, she was from going back to when she started taking a lot of cocaine, she was using quite a lot of dye on her hair. So she was dyeing her hair every 4 to 6 weeks. She used bleach on an occasion. She was also thermal straightening her hair, regularly washing her hair. And if you look at the levels, the red dotted line is the Society of Hair Testing cutoff, above which you would be positive, below which you would be need to be negative. £100 a day, £100 a day of cocaine, and all the 4 months test segments gave us a level that was below the Society of Hair Testing cutoff. So you have a daily heavy user of cocaine that will produce negative, 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 negative as a consequence of those treatments. Now, she stopped dyeing her hair, thermal straightening, early February. And as you can see, the level shot up despite this huge reduction as a consequence of now we're looking at predominantly undamaged hair. We're now seeing a real picture of her level of use. And what we were able to determine was this reduction in use over the last 6 to 8 weeks. The nail that we tested here showed us just how significant her level of cocaine use had been, supporting what she was claiming. But the overriding thing here was we were looking to try and find evidence to determine whether she was compliant or not. Is she telling the truth? Because the numbers certainly wouldn't suggest that. It would look as if she just started using cocaine just before the court hearing. Quite the opposite. We at our laboratory test for things like oxidative markers to determine whether or not hair is damaged when we're not sure. We also test for melanin levels, because if there's no dark melanin in the hair, then what you're looking at in that sample, whether it's damaged or whether they just have white hair, will have very poor incorporation of cocaine. These are things we've learned and things we now can address, but the cutoff ignores all this and does not take into consideration whether this hair is intact or not. Okay, moving on.
That's particularly important for us in the family courts, because very often you might come into proceedings where a hair test has already been done, and then there's a direction that the parent do not cut or dye their hair, and therefore you have a cessation of the use of dye because they've been ordered to do that, which could then lead to an artificial spike, or what seems like an artificial, or what is an artificial spike when you use cutoff levels, because they've been dyeing their hair, no one's told them anything else. Suddenly they're ordered not to dye their hair, and it looks like their cocaine use has gone up, when in fact it hasn't. It's just a more accurate representation of the use at that present time.
This is just to, if you like, show the impact, the real impact that ignoring all the relevant context in a case, ignoring all the relevant or prevailing influences in a case, not having chain of evidence, etc., just applying cutoffs as the industry do. We have here about 3,000 results from cases where we have known outcomes or supported outcomes, and we looked at applying the Society of Hair Testing cutoff to these results where we have known outcomes that we've already reported, just to see the percentages that would have gone the wrong side of what we know. 12% of hair samples in cases where heroin was not being used, had we reported using this cutoff process, then the level would have been above the cutoff, and therefore the industry would have called that a positive test, and therefore would have automatically applied chronic use of heroin. However, the fact that the test said it was above the cutoff is irrelevant. It could have been carryover, it could have been transfer, it could have been contamination, it could be a whole range of things, but none of these other things could be considered because none of these other factors had ever been established. 18% of hair samples in cases where cocaine use was not happening, the industry would have reported positive, and again, you'd have had a chronic user of cocaine. And that's a significant number of cases. When you look at the hundreds of cases that have been dealt with in the courts across the country, in those cases, I mean, clearly the outcome, and not in all of them, but I've certainly spoken to a lot of judges and barristers who saw this almost as the holy grail, this evidence, because it's science. It must be relied upon. It can't lie, and the numbers don't lie. The number is the number. It's what it means. And to know what it means, then all factors that we now understand can impact on the results have to be established, and they have to be considered when we make our interpretation or opinions. If we don't have that background, then we can't report it, and we should say so. So conversely, 22% of samples in those who were chronic heroin users would have been reported negative by the industry. And that could very easily have led to obviously removal of child, which in many cases we don't want that anyway. But in a case where we have a heroin user and this evidence has been used because it was felt there is no risk, quite clearly that underlying risk was just not uncovered because they ignored, again, all the factors that had impacted on this. 20% of chronic cocaine users would be negative. The most significant in numbers is with cannabis. Cannabis is a very different drug to the likes of cocaine and heroin. Doesn't get into the hair through the blood, but tends to get secreted onto the surface of the hair from sebaceous glands, and therefore what happens is cannabis migrates up the hair shaft away from the skin. going up to the tip of the hair. So if you want to know if somebody's using cannabis in the 3 months prior to collecting the sample, the evidence for that is in segments 4, 5, 6, and 7. Very little of that evidence will be in the more recent segments because a lot of it's already migrated away. What this leads to, and this data now, present data, because we looked at it more recently, 68% of hair samples that we test in our laboratory, if we, and this is in chronic users of cannabis, some of them daily users, will be reported as a negative result by the industry because it falls below the threshold above which they would only report a positive. This quite clearly is unacceptable. And I think one of the big problems we have here is that we're not treated as experts. So we're instructed to do 3 centimeters of hair and segment it by month, regardless of the drug. We're not asked to answer certain questions and provide certain information to assist in terms of making a decision. And in the case of cannabis, we are instructed to do something that is not helpful. If we were to do what we want to do in these cases, then a lot of this is legal aid funded and consequently wouldn't get paid because there's a complete ignorance, obviously, within the LAA too. That they feel that it was an inappropriate and overly expensive test when they're not to know. I think one other thing finally on this is that we again are asked to test for the drug. We're asked to test for heroin, we're asked to test for cocaine, cannabis, amphetamine, whatever. Right now, there are numerous regularly used, very dangerous drugs. Things like, for example, drugs called nitazines. These are synthetic opioids that are rapidly taking over from heroin, whilst those on the street are buying what they think is heroin. What we're finding is a lot of this is no longer heroin because heroin is in extremely short supply, having been, I think about 90% of its supply into Europe has dried up. The Taliban have banned the growth of the opium, and they just switch to other things. And there are deaths being reported by the police, doctors in clinics all over the country. Nobody's testing for it. Well, the industry aren't testing for it. We do now cover the 3 most common nitazines. Other things, monkey dust, MDPHP, an awful drug used in certain parts of the country. Never get instructed to test for it. Gabapentin, a pharmaceutical agent, pregabalin, a whole range of both pharmaceuticals but also other problematic drugs are being used, but we never get asked to test for them. And we have to, as Sarah was saying, change the way in which this happens. What you really need to know is substance misuse a risk in this particular case, and pass that challenge over to an expert for them to ask the appropriate questions and then do the appropriate piece of work to make sure you are mitigating the risk and not just chasing your tail, pointing in the direction of the wrong drug, for example.
Which leads us very neatly on to the next topic that Paul and I will cover together on how best to challenge this evidence. Paul's touched on this, but what needs to happen is that this evidence needs to be properly instructed from the start. It needs to be understood that it is expert opinion evidence, and it needs to be dealt with by a proper Part 25 application and a letter of instruction. And as Paul has again alluded to, we should not be telling an expert how to do their job. I can't imagine in a case of non-accidental injury telling a radiologist, take this slide from this angle, take the picture in this way and tell us what it means. And that's exactly what we do in the way that we currently instruct this type of evidence. We say, take a piece of hair, cut it into 3 chunks, tell us what it means. And that is the wrong way to go about it. We should be saying, this is the information we need. You are the expert. You tell us the best way to go about it. And therefore, if you're saying to the expert, the information we need is, has this person used cannabis? over the last 3 months, then because what the expert knows about the migration of cannabis up and down the hair shaft, or the migration of cocaine, if there's hair straighteners being used, or dye having been used and then stopped, the expert might say, in order to know the answer to that question, we have to test for a longer period, because we have to look at the patterns of drugs, and we have to look at potential migration. And we know that the way that the drug might move up and down the hair shaft, as Paul has described. So it's really the only category of expert evidence where we tell the expert how to do their job by saying, you know, do this, do that, cut the hair up in chunks and then test it. And really, we need to be moving away from that if we are to acknowledge this as expert opinion evidence, as the authorities tell us to do. Paul's going to cover about nail testing and why it's important that a sample for nail is taken at the same time as hair, if you don't mind, Paul.
No, absolutely. I think within the instruction, as you're saying, Sarah, it's not really for those instructing to tell us to test this, test that, and how much of it, and all the rest of it at all. And as an example, when we go out and collect our samples and take a full statement of truth from the client, etc., we routinely, unless told not to, in I'd say 98% of our cases, we do collect scalp hair. We collect fingernails, we collect toenails, and we collect body hair. Now, we don't always necessarily need to test all that, but we have it all now in the laboratory. And I would say in about 20 to 30% of cases, it is necessary, or we should be testing a nail, toe and finger, or one or other. Sometimes in addition to body hair, sometimes we don't need the body hair. It's absolutely crucial that we have that, because one of the things that really frustrates when you're doing it through an expert, and the expert knows what they need in terms of data to produce the outcome that you want, it doesn't help if we're only told to test the hair sample. When 20–25% of the samples that we test are clearly not representative. The amount of reports we have to send out that say that presently our opinion is this, however, it could also be represented by X and Z. And the only way we're going to know is if we test a fingernail sample, or indeed a toenail sample. One of the big challenges that we're often faced with is, well, my client says that she's living with somebody who is a drug user. She's sometimes at friends and she knows that they use drugs. So I'm sure what you're looking at in my hair is contamination because I don't use drugs. Now, in those cases, things like a toenail compared to scalp hair can be the evidence we need that can differentiate the two. A toenail is significantly more protected than the scalp hair in these contamination environments. And also, it has a very small surface area relative to its thickness, unlike hair, which is very, very high surface area, and you can get lots and lots of drug incorporated in it very quickly. And consequently, when you see big discrepancies, low levels or none at all in a toenail, but you're seeing this pattern of quite high levels in the hair, then statistically, that has a very high correlation with somebody who's got contamination of the hair. Also, I mean, there are cases where we just don't have scalp hair at all and we have to go elsewhere. I think another benefit with the nail is that we are faced sometimes with those who arrive for collection having shaved their head, chest, arm, legs, pretty well everything, and they've bitten their nails down to the cuticles almost. If you go back to the same individual 2 or 3 weeks later, the nails will have grown. If they're instructed that they can't now clip nails, 3 weeks later, you take a nail clipping and it's covering a very similar period to that we would have taken 3 weeks earlier, because the nail is constantly supplied by the blood all the way until it turns white and you can clip it. Unlike hair, as soon as it starts to leave the skin, it's dead and no longer supplied by blood. and it's open to all sorts of things coming in and out. So a nail is a great piece of evidence. By itself can be a bit of a blunt instrument. You can't segment it. We can test small fingernails and then test a toenail, which grows a lot more slowly, and we can define 2 different periods to some extent, and particularly if we add body hair perhaps sometimes. But I won't go on and on about what we can and can't do. I think what we need is as much information as possible from those instructing. That's context. Where are they living? If they've been living in a drug user environment, are they still in it? If not, when did they move out? Where have they moved to? Etc., etc. Lots of context, very helpful. Full chain of evidence, we take somewhere between 10 and 20 high definition photographs of the whole process, collecting from the scalp. Is it clamped before it's removed? We need to know so it doesn't miss a line, etc., etc., etc. All these things are assumed by the industry. They receive a piece of hair, where it came from. We know it came from that particular individual. Where on the scalp, we don't know. How far off the scalp, we don't know. What have they done to it? We don't really know. There has been a move very recently to things going into reports that say that this person has dyed their hair, therefore the level might be lower as a consequence of that, but they still report it negative. So where do you go from there? You can't go anywhere. You just have to you can't use the evidence. So I think moving on, Sarah, at this point, I think we're opening up why we need to challenge this evidence.
Yeah, so that deals with how to get it right at the start, because if you get to the point where you have to cross-examine one of the representatives from these hair strand testing companies, you've got it wrong usually, and I routinely am lucky enough to be given permission by judges to cross-examine experts, and I often make a lot of headway. Because if we go back to the law and the very basic outline that I did at the beginning, and you think about what the law says should happen, it makes it very clear that the interpretation stage is where results can be judged in the full context of the case and all associated influencing factors. And we've done a bit of a whistle-stop tour through some of the influencing factors. So when you think about how to challenge this evidence, and really that is where you start, has the expert, or I mean, I use the term expert loosely, if the interpretation of this result is just it's above the cutoff, it's below the cutoff, how much of that is expert interpretation? I mean, anyone could do that. Here's a line. Is it above the line? Is it below the line? I would not say that that was a full and proper interpretation. But has this person who has purported to do an interpretation of the number in the hair looked at all the influencing factors? Have they taken a full forensic history from your client who challenges their result? Do they know whether they work in a bar where they're regularly handling notes that might have lots of drugs on? Are they in a relationship with someone that's using drugs? In one of my cases, the grandmother was a drug user. The person I cross-examined had no idea of that, and then readily accepted in cross-examination by me that could account for the drugs found in her hair. She was black, had afro hair, and therefore the risk of contamination was much higher because her hair incorporated drugs so much more readily with someone with a lighter hair color and a lower melanin content. Have all of these relevant factors been ignored by the expert? In most cases, the answer will be yes, because they'll simply take the hair, cut it into 3 chunks, extract the numbers from the hair, and then apply it to a cutoff level. And there really won't be any of the interpretation that the case law says must happen. Part of the problem with the way that hair strand testing is currently instructed, and we'll come on to how we can prevent that, is that if they're not instructed as experts and they're not doing proper expert reports, they're not keeping up to date with current practices and current developments in this fast evolving area of science. We know that from Reedy, it's a very quick moving pace. The industry knew for a very long time about thermal hair straighteners producing AEME, and it wasn't until very recently that we saw that appearing in reports. AEME is a marker for crack cocaine. Have they used thermal hair straighteners? Now, if you're an expert, properly instructed as an expert, it's your role to keep on top of developments in the area and to provide that evidence to in the report to the court when you're reporting. But that doesn't happen now because these reports are pretty much pro formas and they're just all standard, and then they just put the numbers in and say it's above the cutoff. So when you are, first of all, this is expert opinion evidence, and you're entitled to raise clarification questions by Part 25 questions, but the same rules apply to this expert evidence as to a psychiatrist or a radiologist or a pediatrician. You can't cross-examine by Part 25 questions, you can only clarify. And if you've got a case to run, because there are lots of relevant factors that have not been considered at the interpretation stage, then you have a case to put to that expert. I had a case where my client's child was going to be adopted. That was the care plan, supported by the guardian, negative parenting assessment, because they said he'd used crack cocaine and lied about it. Now, he had dreadlocks, which presents a particular challenge because dreadlocks act as a like plug. I'm sure Paul will explain it with more care than that. But he had tested positive for high levels of crack cocaine. And then when we had a nail tested, it was negative for all substances. And it was from cross-examining that expert and putting all of the problems, all the research that they should have really dealt with in the report that didn't, that led to that child being placed with my client and not adopted. If you want to find it, it's a reported case in the Barnet County Court. And it just shows how important it is to properly and rigorously challenge this evidence when you have a case. I mean, obviously, if you have no case because everything's been properly done, then you might not even get permission to call that expert. But in so many cases, it's fruitful to do that. In a case I had where the mother swore that she had given up cocaine in January, but the company said, I think it was Lextox, said she was using in May. I called Lextox. My first question was, where's the photograph to show how much, if any, hair was left on the head? And they said we didn't take one. And the next question was, well, where on the scalp was the head hair taken from? And they said, we don't know. And as a result, the judge, because she was provided with the research articles that I handed up to her and the expert, who I don't think had read them, she was not able to say with any certainty whether the time period that was purported to correspond to that sample was the time period, for the reasons that Paul has outlined. So as we draw this part of the talk to a conclusion, the best way to challenge this evidence is to challenge the expert for the reasons I've outlined. And I've just popped up a case there because there is a body of research available online and soon on the Coram website that provides you with the toolkit to challenge this evidence. The article about the cocaine distribution on the scalp's available. This really demonstrates how unsafe the use of cutoffs are. And in the way that you may cross-examine a paediatrician in a shaking case by putting a number of different scenarios that paediatrician may not have considered properly, the same is absolutely true of this type of opinion evidence. And finally, before we move on to questions, if anyone has any, we just want to point you to some resources that can help you challenge this evidence. I'm not seeking to provide a plug, even though it might seem like it. Coram Chambers has got a resource page, particularly on hair strand testing evidence, where you will find sample letters of instruction, a sample ordered template for the instruction of this evidence as expert evidence and not as a test, because the current standard template order for hair strand testing says, take a piece of hair, cut it into 3, test it, and it does not, we say, properly instruct this evidence in the way that it should be instructed as expert opinion evidence. So there are videos on there, Paul talking about various aspects of drug and alcohol testing. There are articles, and we're working on a toolkit that will help you mount a challenge to this evidence. In the coming weeks, there is a resolution podcast that's going to be made available that talks about some of the difficulties and challenges to this evidence. And if anyone wants a longer presentation of up to 2 hours, then just reach out to Paul or myself, and we'll come to your chambers to talk more about this important topic. There's also 2 articles in the Family Law Journal in July 23 and August 24. Again, you'll find them on the website. Lord Justice Cobb was kind enough to say that he had one of these articles handed up to him. It would be the July 23 article in the case of Reedy when he was deciding it, and he found it very helpful. And I can't really ask for greater praise than that. So there are resources available. We shouldn't all be reinventing the wheel. So reach out for those resources, and that should help you on your journey. And I just want to finish by saying that going back to these statistics, that in any other area where you've got an 18% fail, so 18% of hair samples of people who are not using cocaine test positive for cocaine when cutoffs are used. So 1 in 5 fail rate that could lead to a child being adopted because of cocaine use, or 12% in the case of heroin. In any system where the fail rate is that high, people will be saying that this is not fit for purpose. And really, we agree. So I will close these slides down now and see if anyone has any questions.
Sarah and Paul, I'm sure I'm not alone here. That was so fascinating. And because we deal with care proceedings where you've got the holy trinity of mental health, domestic abuse and substance abuse, this is not something that you may come across when you've got a particular type of practice. If you do care proceedings, you come across this every day, every week. It is so relevant, not only for representing a parent, but also as local authority, you need to know what you're up against and how that evidence is going to be challenged. It was just fascinating. Thank you so much.